The verdict is finally in. In the case of Elon Musk versus OpenAI, the jury has decided that Elon Musk simply waited too long to bring his lawsuit. This is a huge win for OpenAI, who has been fighting Elon Musk for the last 3 weeks in this trial. As we all know, Elon Musk sued OpenAI and Sam Altman along with Greg Brockman, arguing that they breached the charitable trust and that they also engaged in self-dealing, the unjust enrichment claims. There were other claims that Elon Musk had in the complaint, some of which were dismissed and some were still pending. But with respect to the trial that was before the jury today, they have made a decision. The jury found that the statute of limitations had already expired before the time that Elon Musk filed his complaint back on August of 2024. This is a huge and very important win for OpenAI, because ultimately what it means is that the jury never even got to reach the merits of the claims. None of the testimony that Elon Musk presented with respect to the self-dealing and all the other issues was actually considered, because there was a threshold issue regarding the date of when he filed the complaint. Now, this is an issue that was specifically addressed and brought up by OpenAI during the litigation. They wanted a ruling on this issue, but the judge did not rule on the issue. The judge found that the case was so fact dependent that he wanted the jury to come up with its own decision about the dates and all the different facts that went into making a determination on whether Elon Musk actually knew or should have known that he had an actionable claim back in 2021. And I want to go over some of this stuff because these dates were specifically delineated by the judge before the jury was sent back to deliver. For the breach of the charitable trust claim, the jury was instructed to make a determination on whether Elon Musk knew or should have known before August 5th, 2021 that he had an actionable claim. And for the unjust enrichment claim, the statute of limitation and the facts that the judge gave the jury was for August 5th, 2022. So the answer that the jury needed to come up with was, did Elon Musk know back in 2021 and 2022 that he had a claim? Was there evidence of wrongdoing that would have triggered that statute of limitation, and he should have known at that time? That is what the jury determined. They decided, yes, he should have known, and therefore by the time that he filed his complaint on August 2024, it was already too late. The statute of limitation for the breach of charitable trust had already expired, along with the breach of with the unjust enrichment claims. This is a huge win, obviously. With respect to whether Elon Musk is going to actually appeal this decision, we don't know. We shall see what he ends up doing. But ultimately, none of the facts that were presented, none of the evidence that was, presented in this trial with respect to the self-dealing, the different stakes that Elon Musk had, the $2 billion stake that he had with all these other interconnected companies, where he was engaging in business on behalf of OpenAI, where he also had the personal stake on those companies. That was not considered here. None of the issues with respect to Greg Brockman's, diary entries about whether, what was he thinking when, he wrote in there that this is morally bankrupt. That was not considered. None of the issues dealing with the unjust enrichment or the breach of charitable trust was actually considered, because the statute of limitation is a threshold question, which means if you miss the deadline, they never had to reach any decision on all the other issues. We are going to be, following this, because I want to know whether Elon Musk is actually going to fight this or if he's just going to let it go. The entire time, OpenAI had taken the position that Elon Musk is just a disgruntled investor who didn't get his way. They presented evidence that he wanted 90% of the company at some point, and because he didn't get that control, then he is now acting out and he's just going after a competitor. That has always been the positioning that OpenAI has taken, and they presented that information out to the jury. We know that during the closing arguments, OpenAI really went in hard on this argument of the statute of limitation, and they really harped on the fact that Elon Musk knew back, even before 2021, what was happening. He was tweeting about the fact that, according to him, Microsoft was like overtaking OpenAI. He was making his tweets. He knew publicly what was happening with the restructuring of OpenAI, and he left. That's what they argued. They also argued that he was not just some outsider, that he was actually an insider, and he was aware of the internal governing documents, and he knew what was happening. So if you were so dissatisfied and you thought that there was some sort of wrongdoing back at the time, then that deadline applies to you, and you should have filed the breach of charitable trust along with your unjust enrichment claims before the August 2024 deadline that you filed. Elon Musk, on the other hand, argued, yes, maybe there was a restructuring and there was, some for-profit subdivision that was created. However, I did not know about the extent of the self-dealing that was taking place, and I didn't really get to find that out until we were like in the middle of this litigation during the discovery process, where the parties are requested to provide information, and then they have to provide those documents that are requested, in request for productions and interrogatories, etc. So he's arguing that he didn't really know the extent of the self-dealing, so he did not know that what was happening is that these individuals were engaging in self-enrichment at the expense of OpenAI's nonprofit, which they decided to restructure as a for-profit for self-dealing. That is what Elon Musk was arguing with respect to the statute of limitations here. I mean, there is obviously the fact that you don't really get to find out all this stuff, when you're just dealing and trying to invest in a specific company, but you can, and you do have the ability to ask those questions, and you do have the ability to review documents and the term sheets and find out whether this was supposed to ever change or not. In any event, there was evidence, and he did know that they wanted to move forward to a sort of for-profit version of this that can fund the mission, and there were arguments about this, and there was conversations, so he also engaged in those conversations. I'm pretty sure that the jury took all this into consideration at the time. But the bigger question here, and I think the bigger point to drive home, is that ultimately none of that mattered, because the issue was decided on a very technical a technicality. Did you file within the statute of limitations? And in this case, the jury found that he did not. That's what we have, and I'm going to see if he's going to follow any of the other issues and try to move it to appeal. Also, with respect to the Microsoft claim, that also was dismissed because they found that he knew by 2021, and even though they came into the lawsuit a little later, he also missed the deadline to file within the time frame for the statute of limitations. So the aiding and abetting claim against Microsoft with respect to those issues also was dismissed here. That's what we have. We will see what ends up happening in this case. If you like the content and you want to stay on top of the latest AI and intersection between the law, please support the channel, follow and subscribe, share this information with anybody that also may find it useful. Until next time.